and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hello, Richard.
Hello, Lizzie. How are you?
I'm very well, thank you. We're here to revisit a case, actually, that we last spoke about back in July 2023 when it was at the Court of Appeal. It's now been in the Supreme Court and a judgment from the 21st of May, and the case is called URS and BDW, whatever they stand for.
Sounds like an anthem. URS is United Research Services.
Okay.
And BDW is Barrett David Wilson, who you will have heard of.
Yes. So yes, we're coming back to this one because of the new judgment. Do you want to give us some of the background facts, though, to start off with?
Yeah, I mean, URS they're based in San Francisco, but they're worldwide major sort of engineering consultants and also construction and design consultants for buildings. And over the years, they've been designing lots of, in particular, blocks of flats for Barrett's, BDW, a mixture of Barrett's, David Wilson, and various other people who are part of the group nowadays. We did discuss it in the past, but when it was at the Court of Appeal level, as you mentioned, but it was heard by the Supreme Court in early December, and the judgment has been long awaited by many people, and it was on May the 21st. It was actually largely confirmed in the Court of Appeal decision. But it concerned several blocks of flats, 5 blocks between 10 and 18 stories in height, in a place called Capital East, the Isle of Dogs in London, in East London. There's about 350 flats altogether. And there were 7 6-story blocks in Leicester, a place called Freeman's Meadows, which I sort of vaguely know, with another 224 flats in them. And the London blocks were built between 2003 and 4, I think. And the Leicester ones between 2005 and 12, so some time ago. What then happened is Barrett's sold off the freehold. They didn't have any interest in these properties whatsoever when the litigation occurred. They sold off the freeholds, as you tend to do if you were developers. In 2015, I think the last of them was sold off. But they then, kind of fast forward, June of 2017, doesn't seem like that long ago, but that's when Grenfell occurred. And so obviously the aftermath was a great game changer for the whole of the, construction, development, property industry, you name it. People like Barrett's and BDW, I should say, were told basically after Grenfell, they did it voluntarily anyway, sort of reputational things, to actually check all your high-rise buildings, primarily to look for ACM, aluminium cladding and metallic composite materials as well. And they didn't find that, but what they did find is a structural slab in one of these flats in London was cracked, so seriously cracked and in danger of collapse. That particular block had to be evacuated. This was back in 2019. And so obviously emergency works done on the premises, temporary and then permanent remedial works. And they found from the designs, URS had done the designing, they'd found from the designs that none of the other blocks was in imminent danger of collapse, but there was a potential for that in the future. And they were evacuated pending, again, remedial work. And in 2020, Barrett's brought action against URS in relation to the design originally and just the negligence, because the limitation periods under things like the Defective Premises Act had run their course and contractual claims had run their course. But that's the sort of background to it. It's quite a long background.
So what happened in the courts then?
Well, it was primarily just a negligence claim in the High Court in 2021, which BDW succeeded on. They went to the Court of Appeal, but in the meantime, they asked for the pleadings to be amended and bring in some other claims, because in the interim, this is what I find the interesting point, is the Building Safety Act, my favourite piece of legislation of all time, the worst drafted piece of property legislation I've ever come across, as I was quoted in the Times as saying, don't forget that. They various provisions in terms of changing the limitation periods were changed by Section 135 of the Building Safety Act. During the Court of Appeal and then in the Supreme Court, there were basically 4 grounds for making claims. And as we mentioned almost 2 years ago in a podcast, then the Court of Appeal, BDW, succeeded again. And it went to the Supreme Court.
And what did the Supreme Court decide?
Well, the first ground, if you like, which was being argued, was the negligence ground. I'm going to go into the technicalities of it. But URS were arguing that there was no sort of causal link with the loss because BDW didn't have any obligation to do anything. They'd sold the freeholds back in 2015 at the latest and had no obligations. No third parties had sued them or tried to sue them or were talking about suing them, basically. And there's no causal link. You didn't have to do the work. It was voluntary. And the Supreme Court basically confirmed that, then it depends very much. They said it was fact specific and, was it reasonable conduct to do all this work in the circumstances? And because of the possibility of personal injury to the homeowners and obviously damage to property, but also that reputational things, matters. And they also say post-Grenfell, there was a lot of public interest in the developers fixing defects and the likes, and a moral obligation as well for it. So it was a reasonable thing for BDW to do in the circumstances. So they, it didn't matter that it wasn't voluntary, basically, and they could make a claim in negligence. Shall I tell you the second one?
Yes, please.
The second one was about the time periods, limitation periods under the Defective Premises Act under Section 1, precisely. There's a Section 2A nowadays for blocks of flats as well, because it used to be 6 years limitation period. Large numbers of defects, if not a majority, in new build properties and the likes, don't show up until after 6 years. But when the relevant provisions, Section 135, as I mentioned, of the Building Safety Act came into force, that was changed. It was changed it came into force on June the 28th, 2022. And if the defect occurred prior to that date, there's a 30-year limitation period. So going back to 1992, a long, long time, before you were even born. But and me. But if the defect occurs from June the 28th, 2022, it's a 15-year limitation period. But this was obviously defects prior to June 2022, which would have, in the past, been falling foul of the limitation periods. But the Supreme Court confirmed that obviously, if you've already settled, you should read the legislation as if it's always been in place, that limitation period. If you'd already settled your claim or it had been determined in the past before that date, then too bad. But if it's still a claim going through the courts like this, then the 30-year limitation period would apply. And so you didn't fall foul of the limitation period. They actually said it would apply to any other claims dependent on Section 1 of the Defective Premises Act as well, which brought us on to the third situation, which is what Section 1 says, which I suppose you'd like to hear.
Of course.
I'll paraphrase it, but it's Section 11A basically says that if a person takes on work for in connection with the provision of a dwelling, they owe a duty to make sure that the work is done in a workmanlike and professional manner, such that on completion the dwelling is fit for human habitation. And that duty is owed to anybody who well, basically, if they've carried out the works to the order of some other person, come organisation. And Section 11B says that they also owe a duty to anybody who might acquire a legal or equitable interest in the dwelling. So basically, the homeowners and the likes who bought these properties. But can a developer sue the designer? Can you basically sue right down the line, if you like, and get the liability to the person who's actually responsible? And the Supreme Court said, yes, you can. You owe a duty to anybody who you carried out the work to the order of, and that includes developers. They said the whole ethos of the Building Safety Act, amongst other things, I suppose, not the whole, is that work should be done, defects should be found out as soon as possible, and the work should be done as swiftly as possible. And so it's in everybody's best interest that developers find out these problems and pass on the liability to the person who actually is responsible, who often isn't them, it's the designer. So you could bring a claim even though it was to some extent retrospective, if it was still to be litigated or in the process of litigation. And the fourth one, I better tell you, was under the Civil Liability Contribution Act of 1978, which is basically if you've been found liable, anybody else who's liable, you can get a contribution from. None of the actual leaseholders, none of the flat owners had brought any kind of claims against BDW. So URS argues, there can't be a contribution because you're not being sued. But the Supreme Court confirmed that the actual remedial work they did was compensatory in kind for the damage suffered by the occupiers. And so you could get a Civil Liability Contribution Act order as well. And that was basically it. Much awaited. I mean, it's obviously for the construction industry and the litigators, it's got implications for conveyancing because of the limitation periods, what they are. And together with some of the other things in the Building Safety Act, I think Section 130 is now starting to be litigated. A few cases have arisen, and that says that, because obviously developers set up special purpose vehicles, they go through corporate wrapping schemes. When that development's over, the company shuts down, that particular company shuts down. Section 130 allows you to apply for a building liability order, whereby any other associate, the big definition of what they are, can bring claims on, so that you can bring claims against them. If it's just and equitable to do so, you can have a building liability order against the person who's actually to blame. It's a sea change in the whole of development land. And that's it. And that's complicated.
Definitely was. Thanks very much, Richard.
Oh, my pleasure as always, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.